When parents hear legal rights in special education, they usually picture a glass-enclosed emergency button, something you only smash when you are headed for a lawsuit. But your rights under the Individuals with Disabilities Education Act are actually practical tools for daily engagement. You use them to stay informed and guide your child's education long before a conflict ever starts. The instruction manual for these tools is a document called Procedural Safeguards. In New Jersey, you will see it titled the Parental Rights in Special Education, or PRICE document. The school must hand you a copy at specific milestones, once a year, when your child is first evaluated, and if you file a formal dispute. To see how these safeguards work in practice, let's trace a standard, frictionless interaction. You request speech therapy for your child. You sit down with the team at a school meeting, everyone agrees, and the school updates the IEP to include the new service. Knowing what this smooth process looks like is your baseline. When you understand the standard sequence, you can instantly recognize the moment the system breaks down and know exactly which tool to pull out to get things back on track. So, what happens when things don't go smoothly? Imagine you make that same request for speech therapy, but during the meeting, the IEP team verbally refuses. The meeting ends, and you are left wondering what exactly happened and why they said no. This is where you deploy Prior Written Notice, or PWN. The school is legally required to provide this document whenever they propose or refuse a change to your child's program. PWN forces them to put their verbal refusal in writing, detail exactly why they refused, and list the specific data and evaluations they relied on to make that decision. A vague notice is unacceptable. If the document simply says, "The team determined this was not appropriate," the school has not met their obligation. You must demand a PWN that details the exact quantitative assessment scores and observations that led to their conclusion. This visualization compares two distinct legal timelines for requesting those specific assessment records. Under federal FERPA law, a school has 45 days to provide educational records, but New Jersey special education rules are much stricter. The district must provide access without unnecessary delay, and crucially, they must provide them before any IEP meeting or due process hearing. By demanding a thorough prior written notice and securing the underlying educational records, you stop being a passive receiver of a verbal no. You become an active auditor, equipped to review the school's exact decision-making logic. When you face a refusal, your first instinct might be to fire off an angry email, but emotional writing damages your position. Effective advocacy relies on a calm, objective paper trail. Let's test this. Read this draft email sent right after a frustrating meeting. Pause the video right now and think about how you would rewrite this message to simply confirm the facts and request a PWN. Here is the effective approach. You strip out the emotion. Thank you for our conversation today. I am writing to confirm my request for speech therapy was refused. Please provide PWN outlining the data used. This creates a professional record of the refusal while forcing the school to document their reasoning. As you navigate these disagreements, you must understand how your consent rights work. If you disagree with a proposed change to an IEP, you can simply refuse to sign it. That action shields your child's current services. But if you formally revoke consent for special education, the school must terminate all services immediately. You are pulling your child out of special education entirely. Mastering objective documentation and understanding how to strategically withhold consent protects your child's existing supports. It also creates a pristine, factual record if you need to escalate to formal dispute resolution. When documentation and discussion hit a wall, you have formal options. The first step on the escalation ladder is mediation. This is a voluntary process provided at no cost by the state, where a neutral third party helps you and the district negotiate a solution. The next step is a state complaint. This is a written complaint to the Department of Education, used strictly when the school violates a procedural rule, like missing a legal deadline to evaluate your child or failing to deliver a therapy that is already written into the IEP. The top step is due process. This is a formal administrative hearing in front of a judge. You use this for fundamental disputes about your child's diagnosis, placement, or their right to a free, appropriate public education. Because it involves witnesses and evidence, parents typically work with a special education attorney here. During any of these formal proceedings, your child is protected by the stay put provision. By law, the school cannot unilaterally change your child's educational placement while a dispute is actively being resolved. You do not need a law degree to advocate for your child. By demanding prior written notice, maintaining your own records, sending objective follow-ups, managing your consent, and understanding your formal resolution options, you ensure your child gets exactly the education they deserve.